Hey guys, and welcome to today's video. Today, we have two absolute buffoons in court. First, we head to Michigan, where we have a defendant who loses his plea deal because he forgot that he drank alcohol before getting behind the wheel of a car. And then we head to Florida, where we have a Florida man who does Florida man shit. So let's begin.
Ian McLean, turn on your camera. This is 251616 SD, the people versus Ian McLean.
Morning, Your Honor. James Guzicki on behalf of Mr. McLean. He's going to plead guilty to the reduced charge of operating while intoxicated, first offense. And Your Honor, he had a blood alcohol content of 0.168. And also we can cancel the jury trial on November 7th.
Okay, and okay, are you stipulating to that blood draw result for purposes of the plea?
Yes, Your Honor.
All right, Mr. McLean, tell me your first and last name.
First name Ian, I-A-N, last name's McLean, M-C-C-L-A-I-N.
All right, Mr. McLean, you understand you're being offered a plea reduction down to an operating while intoxicated first offense. That's a misdemeanor. It's punishable by up to 93 days in jail, a fine of up to $500, plus statutory costs and court court costs and statutory and court costs. Do you understand that?
Yes, I do.
All right, and up to 360 hours of community service, and 6 points on your license. Understood?
Yep.
Mr. McLean, did you go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes, I did.
Did you understand your rights?
Yes.
All right, and did you give your attorney permission to sign your name on this form?
Yes, I did.
Understand that if you enter this plea, sir, that you'll be waiving the trial rights listed on that form. There will be no trial of any kind. Do you understand that?
Yes, I do.
All right, and you understand that if you're currently on probation or parole and you enter a plea of guilty, it could be a violation of your conditions?
I am not under anything of any kind of legal results at all for anything.
All right, I have to ask you all these questions. I just need to make sure you know. Sir, you understand if you're not a citizen of the United States and you enter a plea of guilty, it could have immigration consequences up to deportation.
I am a citizen of the United States, born and raised here.
All right. Sir, knowing all of that, how do you plead to the charge of operating while intoxicated first offense?
Well,
Guilty or not guilty? Guilty or not guilty?
I guess guilty.
That's not how that works. When making a plea, you are either guilty or not guilty. There's really no guessing involved. If you agree that your actions met the elements required to be convicted, then you say you're guilty, and either you or your lawyer makes a case for how much punishment you think you should receive.
Well, I don't want you to guess, I want you to know. Has anyone forced you to? What that?
No, I was intoxicated. Yes, I was. So yes, I believe I am guilty.
All right, has anyone forced you to get you to plea?
Nope.
Has anyone promised you anything other than the plea agreement to get you to plea?
Nope.
Are you pleading guilty of your own free will?
At this point, yes.
Well, what does that mean at this point? Yes. I mean, it's a yes or no question, so I can't accept a plea if you're not voluntarily pleading. Do you understand?
I do not feel I'm guilty. I was in a rush to go see my daughter. I forgot that I was drinking. I left my home to defuse the situation with my ex-wife. And
Sir,
for the last
were you drunk and were you driving a car on a public roadway? I mean, that's the thing. Like what you're telling me, you just confessed. Basically, I mean, I don't know how you forget you're drunk, but you just told me I don't feel I'm guilty. But I was drinking, I forgot I was drinking, and then I got in a car and drove somewhere.
No, okay. Let me rephrase this. I forgot that I had drank the night before because I fell asleep in my vehicle around the corner to defuse the situation with my wife. The police officer abruptly woke me up, told me my daughter was running around naked outside, and told me to get home. I drove directly home 1 block away from my house to go make sure my daughter was all right. I was not, how do I say this?
I don't know. I'm excited to hear it though. Go ahead.
I was more concerned about my daughter than anything else. She was 3 years old at the time.
But I mean, there's not an extenuating circumstance. You had a .168. I don't know what the heck you drank the night before, but you were twice the legal limit. I mean, the police report is a .168. So it wasn't like you had a few beers the night before and you decided to get in the car. You were super drunk. You were twice the legal limit, according to the blood draw. But I'm not going to take your plea. If you think you have a defense, I didn't hear one, but maybe you think you have one. You have a right to a trial. Let's go to trial next week. And you can let a jury decide if you forgetting you were drunk when you got in the car and operated a motor vehicle on a public roadway. Like, you've given me all of the elements to finding you guilty.
All right, I am guilty. I am guilty, Your Honor.
It's a bit late for that. For the judge to accept your guilty plea, it has to be knowing and voluntary. If you believe mitigating circumstances preclude you from meeting the elements of the charge, then you can't plead guilty, and the only other option you have is taking it to trial.
I don't understand what you're saying when you say you don't feel like you're guilty, though. What part of it doesn't feel guilty to you? I'm being honest, Mr. McClain.
I'm being honest. I was abruptly woken up and I was not thinking straight. I was more concerned about my family than I was everything else at the time. I'm the only person that takes care of my children for the last 3.5 years. I am a single father and I am doing everything I can to take care of them. And yes, I was drunk, but yes, I did forget that I was drunk at the time.
Mr. Gazicki, have fun with this one. All right, we're going to jury trial.
All right.
I'll plead guilty. Yes, I was guilty. That's what it is, and that's where it stands.
I mean, what am I supposed to do with this, Mr. Gazicki?
Can I just ask one question, Your Honor?
Go ahead.
Mr. McClain, do you dispute the lab results that you had a .168 blood alcohol
content?
I'm not
disputing that.
Pardon?
I will plead guilty. Yes, I was. I was intoxicated at the time. Yes.
So I'm asking you, do you agree with the lab report that you had a .168 alcohol in your blood system?
Yes, I do. I cannot deny that.
Your Honor,
so, I mean, here's the problem, Mr. Gazicki. It's not whether or not the elements have been met. They clearly have. It's that the plea has to be knowing and voluntarily. Right. And he's told me he's not really willingly pleading. So the plea's not voluntary.
Okay.
I mean, Mr. McClain, that's the issue. Do you understand that? I can't accept a plea of guilty if you're not willingly pleading guilty. That's what the law requires.
I don't feel I was, but yes, I was. So I don't know how to describe this.
Okay, we're done. All right, thank you. We will see you on your jury trial on November 7th of 25 at 8:30 a.m. in person at the 23rd District Court. Okay? We'll just proceed to trial. That I'm not making a determination. I'm not taking a plea if it's not voluntary. So you're all set, Mr. McClain. Your bond continues. I'll see you next week. All right.
Okay.
All right, so it looks like we'll be seeing this guy again in November for his jury trial. Maybe he can convince the jury that forgetting he was drunk means he doesn't have to pay for his actions. Now we head to Florida, where we have a dangerous Florida man charged with attempted murder who thinks he is the victim.
All right, Mr. Ladson with Mr. Riasti. reads. We have a copy.
Oh, and
Is anyone here from Mr. Lassen's family? Were you hoping to make a statement? No. Joseph Riassi for Michael Allen Ladson, who's present before the court in 2022 CF 827, Your Honor. This case is set for sentencing after jury trial for both the possession charge and the attempted murder charge, where he was found guilty by a jury of his peers. This case had been previously set for sentencing, and the PSI had not been adequately completed. It's been since then. It's been completed and presented to the court. Mr. Ladson has a copy of the PSI, and I've gone over it with him. And we're present to proceed to sentencing.
all right, any additions, deletions, or alterations?
No, Your Honor.
I need to speak. I put in for a Nelson hearing. I've been trying to get him to quit, to take himself off of my case, and he keeps refusing to do it. So I filed for a Nelson hearing. He's been telling me that he was filing. He told me the day we did the last when y'all found me guilty, the day y'all found me guilty the second time on the second charge, he told me that he was going to come see me the next day and we would file an appeal. He keeps lying to me and telling me that he's got to wait until after I'm sentenced, and all he can sentence is the sentence. He's saying he can't appeal the verdict or whatnot. But also, I want to mention, I know that's one thing, but I'd also like to mention this here. You not remember when we sat in here, me and him were sitting here at this table, and you asked Gomez, well, what are these carrying, or what are we doing when we come in here? The last time to prepare, right before, prior to trial, to I guess the possession charge, and he said 3 to 5, and what, 5 to 10, you said? And you remember telling him on a couple of different occasions that there's no min man?
No.
You don't remember that?
I explicitly did not tell him that.
Well, the trials happen, now we're sentencing. The Nelson is tardy since the trial has happened. As to the appeal, the case really isn't finished until the sentencing is concluded. So the period of time to appeal has not begun until the sentence is imposed.
But isn't his job necessary? Isn't it truly done? I mean, once I'm sentenced, he's not really going to be worried about fooling with me anymore, right?
Well,
but I'd also like to mention, like I said, I haven't been able to get him. You know yourself, you've been trying to get me to fire him, and I just hadn't done it. Just trying to go along with the court. It seemed like you've been questioning me, making sure I knew what he was doing. But how is it that they found me? I believe that the questionnaire was wrong because they asked. It's obvious you can't charge somebody with attempted murder after the police reports clearly states there's 3 or 4 earlier altercations. That's attempted manslaughter. I mean, I've been reading up on this. I've been looking.
Well,
I know how the law works anyway. It's 77 what -4 or whatever the numbers are.
Clearly, you don't know how the law works, because attempted manslaughter would be a heat-of-the-moment attempt to recklessly disregard life with your actions. You, on the other hand, got into the altercation, left, retrieved a firearm, and then returned to the scene to mortally finish the fight. Those actions show clear premeditation, thus the attempted murder charge.
yes, sir. Well, that issue is gone. The jury has found you guilty of those charges, and if you believe those were incorrect, then that would be something for the appeal. But you can't get to the appeal until the sentence is imposed.
So there's no way right now y'all can't just back down to attempted manslaughter, make this something reasonable. I've got children out there, I've got responsibilities out there. I can't just go I didn't even speak at the trial. Y'all didn't allow the depots to be used. Y'all didn't allow the police report to be used. And these are all things that are part of the police investigation. These aren't like, and then the two, my attorney never did enter the two negative GSR reports that were put in with the two, with the major fingerprints. What happened to them tests?
Yes, sir.
And why can't I get y'all to provide them?
Yes, sir, those may be issues for some other circumstance, but they're not for today. Today, we're here for sentencing.
I haven't even been to a pre-sentencing investigation. When is that?
Well, you've got the pre-sentencing investigation.
This is all made up stuff. There was one guy come to see me in the jail the other day, but all he asked me was my family's phone numbers, and that's all he asked me, and he left.
Yes, sir. Well, I have the pre-sentence investigation that's been provided, and I guess technically you really didn't, a pre-sentence investigation wasn't required considering your prior history, but I ordered it anyway, and so now we have it, and we're here today for sentencing. So those sounds like all issues that you can take up in an appeal, and you're welcome to do so. And you've heard me say it many times. I have no personal investment in how it goes anyway. If I made a mistake, I'm happy that the people in Tallahassee will correct me.
The last time we was in here before the possession charge, was all that recorded?
Yes, sir. All our proceedings are recorded.
And I've explained, for the record, I explained to Mr. Latson that when I filed my notice of appeal, after the court enters its sentence, I will be asking for multiple for the transcription of multiple court proceedings, not just the jury trials, but the preceding, a few of the preceding hearings, and then the sentencing hearing and any other hearings in between.
All right. State wish to proceed.
Yes, Your Honor.
Go ahead.
Your Honor, we're here to sentence Mr. Latson on 2 counts, one of them being attempted second-degree murder with a firearm, and the second being a possession of a weapon by a convicted felon. With respect to count 1 of that, the exposure is life. This is a 1020 life statute. We proceed under the 1020 life statute. The jury found Mr. Latson guilty of attempted second-degree murder, but then further found the required 3 findings: that he committed it while possessing a firearm, that he actually discharged that firearm, and that he caused great bodily harm to the victim by discharging that firearm. The facts of this incident, I'm not going to harp on them, but just to be brief, this incident was where the defendant had a run-in with the victim and his friends. He was told to leave the premises. About an hour went past, and Mr. Latson chose to go and get a firearm, to load that firearm, bring a loaded firearm into a public building, and discharge that firearm. I think we are extremely lucky that the defendant, or the victim rather, did not die that night.
That sounds like attempted murder to me.
Given the individual or the defendant's status as a convicted felon, count 2 is going to carry with it a mandatory minimum sentence of 3 years. Given the potential exposure, I believe the minimum guidelines shows 272.55 months in the Department of Corrections. This is a 25-year mandatory minimum because of count 1. On count 1, there's 25-year mandatory minimum. We do feel as though, even still, the defendant is showing absolutely no remorse for the actions that he took that night. He is still trying to find every little possible way out of facing accountability and responsibility for those actions. Your Honor, because of this, we are respectfully requesting 40 years on count 1, 25 years of it being a mandatory minimum sentence, and then we are requesting 15 years as to count 2, with 3 years of it being a mandatory minimum sentence. Those would run concurrently, Your Honor.
Mr. Riosti.
Your Honor, Mr. Ladson, we never really went into the proceeding, what happened prior to that, because the victim had passed away from unrelated issues. If he was able to take the stand, we would have been able to discuss some of the preceding events that had occurred. In mitigation, the victim, there were a number of arguments prior to Mr. Ladson entering the bar. They occurred at other bars. And during the evening, and at one point he was pushed down on the sidewalk in front of chasers. It's certainly not a justification for entering a bar and discharging a firearm. They shoved him down on the pavement outside. The testimony at trial, he entered the bar and pointed the gun at the victim, and there was inconclusive testimony as to whether he was struck in the face prior to discharging the firearm, or the firearm was discharged at the same time. It's possible that Mr. Ladson was just going to angrily assault the victim. It certainly is possible that when the gun was discharged, that the victim might have been shot in a more egregious location. The state had argued at sentencing that it was in their final argument at trial that but for him striking Mr. Ladson in the face, he might have been shot more fatally, basically. But it's a possibility that that Mr. Ladson's purpose wasn't necessarily to fire the weapon.
Then why did he fire it? And I'm sorry, but as much as the defense attorney is trying to mitigate the circumstances for sentencing, I think it's a very poor argument to say that if he didn't get punched in the face while trying to kill somebody, he might have unfortunately been successful. Now, I don't blame the public defender though. He's doing the best he can while working with less than nothing.
And I'd ask the court to consider that in sentencing. 25 years is a significant sentence. The court has entered a sentence today on felony murder where two victims were deceased in a plea agreement for 25 years. And I think in this case, where the victim was injured, that a 25-year sentence is just and appropriate. So I ask the court to sentence Mr. Ladson to the 25-year minimum mandatory sentence and run all the rest of the sentences concurrent with that.
I'd like to say one more thing. I didn't testify myself. I figured just the physical evidence alone would take care of everything itself, just because the physical evidence did not point to me having a gun or firing one. But I didn't even have a gun that night. We got in a fight over the gun because they come over him when we was fighting. They come over him and tried to shoot me. I was trying to take possession of the gun, and that's why I keep bringing up the fingerprints, because there would have been 7 or 8 different fingerprints on that gun. So, I mean, I understand you saying that you can't make any special accommodations, but is there not a way can I not claim a mistrial or something? There's got to be something I can do, right? I mean, I don't understand how I can just be left here hanging. There's got to be something. And I've got money on the streets. I've got a trust fund. I could get my own attorney. I looked in. I looked in through the jail to get them to get me like a caseworker or whatever, so I could, take care of finances or whatever on the streets, since I don't have anybody to help me out. And they told me they don't offer them services.
Anything further on your sentencing arguments?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
Well, and I understand your argument about, sentences and consistency. What's the difference between this case and the case that I just issued a 25-year sentence on? What's the difference between that case and this case?
I mean, the defendant entered a plea. He
with agreed upon sentence with the state, right?
Yes. It wasn't agreed upon then.
And so I don't accept every plea offer I get, but when there is agreements, generally that's the situation. So that's a...
For the record, Your Honor, my comparison was more in the fact that there were two bodies in that sentence, and there are no bodies in this case. Mr. Meeks was shot and wounded, but he recovered, and that's the gist of my argument with regard to the 25 years as a significant sentence and appropriate for a scenario where there's no one suffered a fatality.
And how is it, Your Honor, like I've got my siblings went to school with a fellow named Donnie here a couple of years ago, shot 4 people, and he did 4 years and admitted to it and got 4 years. He did 4 years to the day. How is it that y'all are going to hit me with 25 years? It's not fair. I mean, I don't know the boy's last name, but it's definitely not fair treatment.
Well, life's not fair, and it's even more unfair when you choose to be a lifelong degenerate criminal. But now it's time to close out this ordeal and send him away to his new home for the next 25 to 40 years.
Well, the law says that under the circumstances presented, I can't do anything less than the 25. That's what the law provides. I don't have a choice in that matter. So the real question is, should I do more than 25 based upon the evidence that I heard at trial? Mr. Gomez is arguing that based upon the evidence that I heard at trial and after reviewing the sentencing, the pretrial investigation, that 40 years is appropriate. So that's the question. But the 25 is the minimum that I can lawfully give because of the 1020 life statute and based upon the jury's finding. So I don't have the ability to do anything less than that, lawfully. And so that's the only question. And the charge carries the potential of a life sentence. And the conviction carries the potential of a life sentence with the 25 minimum mandatory based upon the nature of the charge. And so I've read carefully the pre-sentence investigation and read the circumstances. And I understand that you do have children and you do have family, and your criminal history is in some ways significant, but in other ways episodic. It doesn't show a consistent, persistent pattern behavior that I see in some cases. And then I also read some of the information here which to the court suggests that there are some mitigating circumstances here which would induce me not to impose a life sentence, which under ordinary circumstances of the jury's finding would be clearly something that I would do of coming into a public place, a crowded public place, and intentionally shooting someone, as the jury has found. I know you contest that that's the truth, but that's what the jury's found, and that's what I'm bound by. Ordinarily, I would think a life sentence would be the appropriate sentence under those circumstances because of what that does to public confidence and trust in being safe where we are, safe where we want to be. That creates an environment where it just is not acceptable in our society and environment. Looking at the mitigating circumstances described, I can see that there are things that would tell me that that might not be the circumstances. But then also reading it, it seems that there are other circumstances that make me question whether or not that isn't the appropriate, particularly the ongoing substance abuse and erratic behavior that significantly impair your judgment, rendering you unreliable and contributing to emotional and behavioral instability, estrangement from your children and persistent conflict with extended family members, which have deeply strained familial relationships. And the fact that the recent arrest simply underscores a pattern of poor decision-making and an inability to avoid high-risk situations, suggesting the presence of unresolved underlying issues. And so, particularly when the court considers, even if I were to accept all of the facts that you've given me as true, that you were abused at the hands of these people, there was a period of time of almost an hour from everyone's testimony between these interactions and your decision to go home, according to the testimony and the finding of the jury, to go home, procure a firearm, and come back to the bar. Even if it wasn't you procuring the firearm, even if it is, as you said, someone else had a firearm and you grabbed the firearm, you were told to leave. But instead of leaving, you decided to come back and have another confrontation, putting yourself clearly in the zone of danger and putting other people clearly in the zone of danger. That's consistent with the findings. I'm not convinced that if I don't impose a significant sentence on you, that the public is going to be safe and is going to be in a position of being assured that they can be safe in their environments where they go. So under the circumstances presented, I'm going to impose on count 2, I'm going to impose a 15 years state prison on count 2, concurrent with count 1, and 30 years state prison on count 1, 25 of which is minimum mandatory, and on count 2, 3 years of which is minimum mandatory. No supervision to follow.
Well, there you go. 25-year minimum, potentially 40. And that's not because Florida's feeling generous. It's because the second you grab a gun as a previously convicted felon, the law basically says, congratulations, you've unlocked the game of life. No parole edition. Now this guy didn't just snap. He argued, left, grabbed a gun, and came back shooting. That's not heat of passion. That's attempted murder. So if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content.